The power of the president is plainly coupled with a duty to maintain the constitutional institution, the constitutional provisions, the constitutional scheme, and the sanctity of solemn agreements entered into by the predecessor of the union government, which are accepted, recognized, and incorporated in the constitution. An order merely de-recognizing a ruler without providing for the continuation of the institution, which is an integral part of the constitutional scheme, is therefore plainly illegal. Because Madhav Rao was a judgment of a bench of 11 learned judges, and Justice J.C. Shah, His Lordship Justice J.C. Shah was speaking for 7 himself and 6 other learned judges, for 7, the majority of 7. I think there were some concurring and some dissenting opinions. But I'm just placing this that these powers have to be exercised bona fide, and I don't see anything, certainly not in their counter, but there's no justification whatsoever for why these 2 provisos had to be suspended and what nexus that would have with the proclamation under 356. That's the first point. Now, may I just skip over the second point, that timeline? I'll come back to that. I've made just a one-pager where I set out that timeline. I can come back to that. Since the question fell from my lords about the background to union territories and how they came about and so on, and what is their status in the constitutional scheme. Yeah. So this is, if your lordships are kind enough to see what happened, I'll just summarize it and I'll take your lordship straight to the relevant provisions. 1905, Lord Curzon, my lords, split the province of Bengal. This was done unilaterally as a Governor General. That led to the partition or bifurcation of Bengal, led to a tremendous backlash against the British Raj. And there were huge protests, a lot of killings, etc., etc. And ultimately in 1911, Lord Hardinge was compelled to rescind that move and restore Bengal as one province. Now, this experience led to a declaration by the British Parliament on 20th of August 1917 to devolve greater power on India, and particularly on the provinces of India and the representatives of the people in those provinces. And this, your lordships will find, the declaration by Parliament led to the 1919 Act, the Government of India Act 1919, which specifically provided for the original precursor to Article 3. So the 1919 Act, along with that declaration, your lordship will find, volume 18 of the documents, and it's that proclamation, that declaration is very important, Lord, and as also the preamble to the 1919 Act. Volume 18, page 14, PDF 14, is the declaration of 20th August 1917.
Volume 18, page?
Volume 18, PDF 14, is the declaration of 1917, 20th August 1917. It's very short. May I read it, please? The policy of His Majesty's government with the Government of India and complete accord.
Have you got it?
Page 14. I'm so sorry. Volume 18.
The Government of India Act 1919, right?
Yes.
We have section 3 there, 3.1.
Yes, but the declaration is at PDF 14. The declaration of 20th August 1917.
No, that's not at page 14.
Page 14 is the Government of India Act.
Volume 18 lives PDF 14.
No, that's 10849, which is the page you're getting.
10835.
Oh, 10835.
Okay. Yes, I don't know why my PDF. Oh, there must have been an earlier version. I'm so sorry. 10835. Does anybody have the correct page?
53.
What page is it?
I had it at PDF 14 because that was what was given to us.
10835.
The declaration of
20th of
the,
August PDF.
Declaration of 20th August 1917.
the PDF.
It starts with the policy of His Majesty's government, with which the government of India are in complete accord.
PDF page 14, yes, it's there.
We all have it as PDF 14. I think that
Yes, 835, right? It's 10835.
10835. And on this side, we all seem to have it at PDF 14. I don't know, there's some mismatch. My lord, find it now.
Yes, just one thing. It's from Yalapura.
Yes. This is from extracted, all this entire book is here in this volume, which is the Working Constitution in India by S.M. Bose, the 1921 publication.
Yes.
The policy
Yeah,
of His
just one second,
Majesty's
let's get
government,
that.
with which the government
Just
of
one,
India.
Mr. 1 second.
Where's Prasanna? My Lord, Honorable Justice Suryakant finds it. We're going to have a problem with PDF 58 also by the section. Perfectly matched. There's some. I could hand up an iPad if for my lord. Your Lordship, 10835, the running page. The declaration of 20th August, the policy of His Majesty's government, with which the government of India are in complete accord, is that the increasing association of Indians in every branch of the administration and the gradual development of self-governing institutions with a view to the progressive realization of responsible government in India as an integral part of the British Empire. They have decided that substantial steps in this direction should be taken as soon as possible, and that it is of the highest importance as a preliminary to considering what these steps should be, that there should be a free and informal exchange of opinion between those in authority at home and in India. His Majesty's government have accordingly decided, with His Majesty's approval, that I should accept the Viceroy's invitation to proceed to India to discuss these matters with the Viceroy and the government of India, to consider the Viceroy views and the views of local governments, and to receive with him the suggestions of representative bodies. I would add that progress in this policy can only be achieved by successive stages. The British government and the government of India, on whom the responsibility lies for the welfare and advancement of the Indian peoples, must be judges of the time and measure of each advance, and they must be guided by the cooperation received from those upon whom new
Mr. Singh, what is the relevance of this actually?
Then, Your Lordship, just see the preamble. The progress, when Your Lordship sees the particular section, the preamble then was based on this of the Act in 1919, was 5 pages down. If Your Lordship just scrolls down 5 pages to the Government of India Act. Now, the preamble to the Act specifically said the 1919 Act, whereas it is a declared policy of Parliament to provide for the increasing association. So based on this same declaration, there was the
Were the
PIF, and
union,
then
were the
particular
UTs all
provision-
were the UTs all a part of the Part C territories?
So I'm just coming to that provision then straight away. If your lordships, I have it at PDF page 58.
And before the constitution came into force, where were these Part C territories comprised?
Yeah. So there
They were the chief commissioner's provinces.
yes, that's right. So there were the governor's provinces became Part A states. The governor general and then later the governor. So Bombay province, Madras province, Calcutta, Fort William, etc., became the Part A states. The Indian states, which
Became Part B.
not all of them, there were 562 states, those which could be merged and made into viable states, because viability was the main crux here.
But J&K was also a Part B state.
That's right. So those which were viable as states, all Indian states which were viable either standing as they stood or by merger became Part B states. Those which were
Now, in the Government of
where
India Act, what was the classification of the territories in the Government of India Act?
Yeah, that in the Government of India Act, there were governors' provinces, there were chief commissioners' provinces, and I'll just show that.
So we must look at what was the position in the Government of India Act,
That's right.
how that transformed into the Constitution.
Yes.
So that will give us an idea of how the union territories were created.
Yes, and in fact, in the
The union
Constitution,
territories came into being. One thing is very clear: the union territories came into being with the Seventh Amendment in
Seventh Amendment.
1956.
So in the Seventh
That
Amendment,
abrogated the distinction between Part A, Part B, and Part C states and the Part D territories,
yes,
and then brought the entirety of India into the states and the union territories.
union territory. Now, so I'll just show your lordship the progression. So if your lordship sees here, please come straight away to PDF 58, which would be in this same volume. It's 10879 running page.
Page 58.
But your 58 won't match because 14 wasn't matching. Could your lordship tell me what was your equivalent PDF for 14?
The difference is 14 pages actually.
14 pages, 14 more. So this 58 would be 72, perhaps around 72, 1087, 10879. It should be a PDF 72 if there's a difference of 14 pages.
How does it start?
Section 14 is on the top, Government of India, 10879 is the running page. The printed page number is 44 and it's PDF, we have PDF 58, all of us here.
PDF 72 is 10907.
109.
PDF 44.
Oh, it's 14 less then. So it should be 44, perhaps PDF 44. PDF 44 should work out. 43 or
You're referring to internal page 44. PDF is 58. Section 14 you're referring to.
Yes,
14, right?
we are getting PDF 58.
That is
internal page-
10879.
Yes.
That is page 44, I think.
No, that's page
Yeah,
44.
yeah,
PDF
yeah.
is page.
So your lordship's PDF is matching the internal page number, I think.
No.
Page.
So now 15.1. Which page? But on, what I'm taking your lordships to is the precursors to Article 3. But to answer the union territory aspect, in my written submission, Your Lordship will find that.
So now we are at 10879 with a great effort. So let's focus on that. We don't lose this precious page.
So this is the precursor to Article 3 in the 1919 Act, Section 15.
Section 15.
Yes.
All right, let's see that.
And the marginal note is constitution of new provinces, etc., and the provisions as to backward track. The Governor General and Council may, now please note, after obtaining an expression of opinion from the local government and the local legislature affected. This is why I was reading that preamble and the declaration of the King, His Majesty. The Governor General may, after obtaining an expression of opinion from the local government and the local legislature affected, by notification with the sanction of His Majesty previously signified by the Secretary of State and Council, constitute a new governor's province or place part of a governor's province under the administration of a deputy governor to be appointed by the Governor General, and may in any such case apply with such modifications as appear necessary or desirable all or any of the provisions of the Principal Act or this Act relating to governor's provinces or provinces under a lieutenant governor or chief commissioner to any such new province or part of a province.
Therefore, that is the power to constitute a new governor's province.
Yeah.
Yes.
And then subsection 2 deals with backward tracks. We are not concerned with that. This was then carried forward in section 290 of the 1935 Act.
Where is that?
That Your Lordship will find. Look, I'm sorry, in this, could Your Lordship just read the footnote to this? Section 15, there's a footnote of the committee report, which is very important. This is in the whole thing of self-governance. The footnote is on the next page. For constituting, the committee have two observations to make on the working of this clause. On the one hand, they do not think that any change in the boundaries of a province should be made without due consideration of the views of the Legislative Council of the province. On the other hand, they are of opinion that any clear request made by a majority of the members of a legislative council representing a distinctive racial or linguistic territorial unit for its constitution under this clause as a sub-province or a separate province should be taken as a prima facie case on the strength of which a commission of inquiry might be appointed by the Secretary of State, and that it should not be a bar to the appointment of such a commission of inquiry that the majority of the legislative council of the province in question is opposed to the request of the minority representing such a distinctive territorial unit.
Now, where is
this is that what I was saying about the arbiter, Parliament being an arbiter when there is within a state.
Where is the Government of India Act, section 290?
290, Your Lordships will find in volume 6, my lords, of the document. PDF 113, and I trust, this time we'll all be on the same page, Mrud. Volume 6.
Volume 6.
Page?
Page 113, Mrud. 290 is almost in the same form in which Article 3 came to be enacted by the Constituent Assembly.
What is the page?
Your Lordships have page 113, Mrud? PDF 113?
113.
113.
Volume 6, no, document volume 6. Creation of new provinces and alteration of boundaries of provinces.
Which is the, and how are the provinces distributed under the Government of India Act, actually?
Section 5 of this.
Yeah. 5 refer to? What is the PDF page for page?
PDF page 18, I'm very grateful to Mr. Shankar.
18.
Yes, Proclamation of the Federation of India, PDF 18 of this same volume 6 minutes. Establishment of Federation and Accession of Indian States, Proclamation of Federation, it shall be lawful for His Majesty. May I read that? If an address in that behalf has been presented to him by each House of Parliament, and if the condition hereinafter mentioned is satisfied, to declare by proclamation that as therein appointed, there shall be united in a federation under the Crown,
No, but it's kind of important because it says it shall comprise of the provinces, hereinafter called the governors' provinces, and the Indian states which have acceded or may thereafter accede to the federation. And in the federation so established, there shall be included the provinces hereinafter called the chief commissioners' provinces.
That's right. Then the conditions referred to is that states the rulers whereof will in accordance with the provisions contained in part 2 of the first schedule be entitled to choose not less than 52 members of council of state, and the aggregate population whereof as ascertained in accordance with the said provisions amounts to at least one half of the total population of the state so ascertained have acceded to the federation. Then the manner of accession is in section 6. And the footnote notes to section 5. It says section 5 was substituted as follows. This is not the after 15th August 1947. I think this was in 1948.
This is important.
Government of
because
India Act was.
So, with the Indian Independence Act, we got the governors' provinces, the chief commissioners' provinces, the Indian states in the manner hereinafter provided, and any other areas that may be with the consent of the dominion included in that dominion.
Yes, and this was not under the Indian Independence Act. This was an amendment to the Government of India Act 1935.
Right. Following the Indian Independence.
Following the Indian Independence Act, absolutely. Because till then it was only the British Parliament which could enact the law. After 15th August 1947, the amendments were made by the in the Dominion by the Dominion.
Now, were the chief commissioners' provinces is referred to in any schedule to the Government of India Act or no?
Chief Commissioners provinces, no, I think it's in the 1919 Act, but just check in the 1990. Just check it. Page?
Page 49.
Oh, of this very thing?
Oh, I'm very grateful. Part 4, the Chief Commissioner's provinces, correct. At PDF 49, my lords, have that? Section 94 onwards. My lord will find this, my lord, Honorable Justice Suryakant will find it
Yes.
PDF 49. Madam.
Yes. Good.
Part 4, the Chief Commissioner's provinces. The following shall be the Chief Commissioner's provinces, that is to say, the heretofore existing Chief Commissioner's provinces of British Baluchistan, Delhi, Ajmer, Merwar, Kurg, and the Andaman and Nicobar Islands, the area known as Pant Piploda, and such other Chief Commissioner's provinces as may be created under this Act. Aden shall cease to be a part of India. A Chief Commissioner's province shall be administered by the Governor General, acting to such extent as he thinks fit through a Chief Commissioner to be appointed by him in his discretion. Then British Baluchistan is set out in
So
95.
now from here we go to the Constitution. Would it be correct to say that when the Constitution is adopted on 26th of January 1950, the territories were comprised into Part A states, which comprised of the governors' provinces, the erstwhile governors' provinces. Part B states, which were the Indian states which had acceded to the dominion of India. Part C
No, only
states.
such of those which were viable.
Right, we're not now on the Jammu and Kashmir thing at all. We are now looking at the broad.
Yes.
So this
In
argument is independent of the J&K issue.
Yes,
Part C states were the erstwhile chief commissioners' provinces.
yes.
And Part D states were the other territories.
No, and Part C
Let's
state
look at
also had one more category.
Let's look at the Constitution as of 26th of January 1950, because that schedule will give us the distribution between what was Part A, what is Part B, Part C,
Yes.
and Part D.
Just one qualification. I
That
was
whole
not-
the Part C states had the Raj Pramukh.
That's right.
I think Part B also had the Raj Pramukh. Part C had the Raj Pramukh. Part A had the governors.
That's right.
And that continued from 1950 to 1956.
That's right.
56, following the Fazal Ali Commission, everything is abrogated and you just have states and union territories.
That's right. But just one small qualification. Part C states also included Indian states which were not able to be merged into a viable unit. So, for instance, Himachal Pradesh was consisting of 30 Indian states, 30 small Indian states. But because the province of Punjab, the governor state of Punjab came almost to the edge of Shimla at that time, there were hill areas of Punjab, and they automatically went as a part A state. So Himachal Pradesh, with its 30 states acceding and merging into it, still was not viable. So it was a Part C state, though it was Indian states, but Part C. So there were several such cases of those which were not viable as independent statehood at that point in time. It became a Part C state. It became a union territory in 1956. Then in 1966, when Punjab demanded a Punjabi Suba, and there was a huge movement and agitation, etc., as a negotiation to give Punjab a linguistic state, Haryana was carved out, and the hill areas of Punjab were carved out and given to Himachal. It still continued temporarily as a UT, and in 1971 it was made into a full state.
Now, do we have the constitution, just to complete the whole exercise?
Yes.
The constitution as of 26 January 1950, where is that?
Yeah.
Yeah, they can put it on the screen.
All right, they'll put it on the screen actually.
If your lordship, in the meantime, may I just very quickly take your lordship to my written submission, a very brief thing on how this transition took place, page 468 of my written submission.
So, Mr. C, you're saying at the time when Punjab, the division of Punjab took place, there were two union territories. Himachal Pradesh was carved out as a union,
And Chandigarh,
and Chandigarh was carved out.
because of the,
Correct. There were two union
That's
territories
right.
which were carved out.
That's right. That's right. Absolutely, your lordships are right. In fact, this is all in my note, but even in the written submission. But the point here is, right from the 1919 Act, the progression has been consistently and continuously towards greater self-governance, and greater self-governance in the form of full statehood.
We are only on the, today, for that, the question is legality of that order in terms of Article 3.
That's right. That's right. So, but the context in which the reading that I would seek to persuade your lordships to adopt is one which would be consistent with that objective of greater self-governance. When we read Article 3 as opposed to Article 368, that greater self-governance and the move that, because keep in mind that barring these small, unviable or special status union territories, Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, etc., by 4th of August 2019, there were only 7 union territories left in India. And the 7 were Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, Daman and Diu, and Puducherry and Puducherry. These were the 7 union territories left. All others were merged or amalgamated.
Now see what they have put up on, it's very interesting. Part A, this is on the date of the constitution. Part A states are basically 9 states. Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, United Provinces and West Bengal.
That's right.
Now let's see part B, थोड़ा सा scroll कर लीजिए.
Part B.
We get this.
ये कहाँ से मिला आपको?
Part,
अच्छा, गोपाल के.
part B states,
Now part B are Hyderabad,
Jammu and Kashmir, Madhya Bharat, Mysore, Patiala and the East Punjab states, that's the PEPSU, Patiala and East Punjab States Union, Rajasthan, Saurashtra, Travancore, Cochin and Vindhya Pradesh.
right.
Then your lordship sees the territories of the state. The territory of each of the states in this part shall comprise the territory which immediately
थोड़ा
before
scroll
the
कर लीजिए.
commencement of the constitution
थोड़ा
was
सा ऊपर
comprised
कर लीजिए.
in the corresponding Indian state, and in the case of each of the states of Rajasthan and
थोड़ा ऊपर
Saurashtra
कर
shall
लीजिए.
also comprise.
जम्मू एंड कश्मीर का टेरिटरी देख लेते हैं क्या है. थोड़ा सा ऊपर कर लीजिए. और जाइए ऊपर. थोड़ा नीचे. नहीं, ऊपर ऊपर.
Now your lordships will see that some of those commissioners' provinces
ऊपर जाइए आप.
were merged into Part B states because they became viable. Pipoda,
हाँ, वही पर. अजमेर, भोपाल, बिलासपुर, कूच बिहार, कूर्ग, दिल्ली, हिमाचल प्रदेश, कच्छ, मणिपुर एंड त्रिपुरा.
Himachal Pradesh was at that time also.
पार्ट सी में था.
Was it not included in Punjab?
Yeah, yeah.
It was later on included in Punjab.
And ऊपर जाइए थोड़ा सा.
Punjab was.
And then part
Now,
B.
if your lordships come to part C state,
The second paragraph of each of these parts in the schedule describes what they were earlier. If your lordship sees part A, part B, part C, they have explanations below the list. No, it's there. It's
yes,
part of this.
if your lordship just goes below part B, territories of states,
Below the list, these territories they have for each of the parts. Now, the second explanation there describes where they came from.
beneath each of the lists, the territories are given, and that shows how different units were merged into them even on the beginning of the constitution.
Right.
I have also got a table in my
And part D only comprised of Andaman and Nicobar.
Andaman and Nicobar, which was a chief commissioner's province in the 1935 Act. But that was carved out separately.
So Ladakh is a UT and the change of status from a state to a UT of Jammu and Kashmir.
Yes, sir.
Both aspects.
Both. First of all, just the conversion of a state into a union territory, I submit, is only if at all it could be done. I submit it violates the basic structures. It can't even be done under Article 368. But if at all it could be done only by under Article 368 because it clearly impinges on at least 6 or 7 provisions in the proviso. So it would require both the special majority and ratification by more than the legislatures of more than 50% of the states to convert a state into a union territory, and I'll make good that submission.
Therefore, I refer to two different things. Carving, the change of status is one, and suppose Jammu and Kashmir assembly status was maintained and only UT was carved out, then what could be argued?
Even so, Manoj, the submission really is that for Ladakh and for Jammu and Kashmir, Manoj, the exercise which has been done is one which is clearly beyond the purview of Article 3. It was not permissible under Article 3 at all. Even if it had been rightly done, I'll show from the timeline that it's actually not even done as per Article 3. But assuming it were rightly done under Article 3, this is not the scope of the power of Article 3. When I take your lordships through the provisions of the Constitution, your lordship will see Article 295, Article 294, etc. A state comes with property or lands, property, consolidated fund, rights, contracts, right to raise money. It has absolutely sacrosanct powers under Article 73, read with Article 162. The executive powers, the legislative powers.
Your 1 hour, how long would you now take?
Look, I'll try to be as brief as possible. I think it will take about an hour or so.
No. 1 hour, no, Mr.
Look,
Can't be 1 hour. Can't be.
I'll tell you also, this is what I'm arguing is something nobody else has argued, but the main thing here is we are saying
What is the point
that
of this
regardless of what.
What is the point of this chart then?
Look,
Because over the
independent.
schedule, you're supposed to have a kind of a arguing comes, discussion.
Look,
1 hour, you take 2 hours, then this schedule means nothing.
Look, I acceded to your lordship wishes and I confined myself from day one. I adopted other people's arguments. I'm not touching on 370 at all. I'm saying that and if at any stage your lordship feel that I'm going beyond the purview of there are the 4 or 5 points which I outlined at the beginning.
You've made your 4 points, but you have made your 4 points now, and your argument really is this, that look, insofar as they're twofold. You cannot convert an area which is comprised in a state into a union territory. Now we have seen the history of the creation of the union territories.
Yes.
Because when you create a union territory, we've also, the people who have preceded you, they have said that, look, the whole essence of a state is democracy. You have a legislature, you have elections, you have converted it into a union territory which has no legislature, which has no elections over the past 4 years. Therefore, that's one aspect. The second aspect,
and the large bulk
and the second
of the
aspect
state
of your
has become
submission
without a
is
legislature
that
altogether.
the second aspect of your submission is that you can't use the Article 356 power to suspend the 2 provisos to Article 3 and then use that to complete the process of conversion of these states into. So these are the two key areas really. I think we can give you another 10 minutes now.
I'll go with, no, I won't be able to do it in 10 minutes. And I think your lordship will perhaps accept my
Actually,
submission.
Mr. Singh,
That there are some.
everybody has argued this point also before. Just that.
Lord, I will not repeat a single argument that anybody has made. I'll take your lordship
Right,
very.
3 to 3:15. We'll give you 15 minutes, I think.
Lord, I'll go as quickly as I can.
Minutes and that's it. Now,
I don't think I'll be able to do that. No, then I
Mr. Singh,
Fair-
advisor.
I'll go very quickly, Lord. I will not take extra time on anything. I'll just go point wise and place the
Because
relevant pages.
tomorrow they have to start arguing. Between all of you, we decide now, we'll give you a little more time, but it will cut into somebody else's time. So who that person is, you please decide for yourself.
No, I think that that may not be proper in this case.
No, delimitation, for instance, we are not concerned with delimitation here. Delimitation is not an issue in these petitions. So we have to now, the delimitation argument, Dr.
No, I'm
It's
not arguing on delimitation.
No, that what we are trying to say is that at lunch, you reorganize the time between yourselves because delimitation will not arise at all in this.
I think your lordship may need to give us a little bit of time tomorrow, a little bit of time.
No. We'll conclude today of all this side, yes.